whether it be moving forward or not moving forward, is that an appealable decision? And if so, based on the new regulations, does that mean it only can be somebody that is adversely affected, somebody that lives very close or something, as opposed to anybody in the municipality or, like you said, a corporation? That's another one. And salvage yard, which is no longer, is not permitted in any zones. As David and a couple others have pointed out, that some of those, it does appear that there's a bit of a salvage yard at the property question on a couple things, plus parking lots, which can't just go on an unoccupied parcel, but we won't go there. But for a salvage yard, if somebody is operating one, at what point does it go from municipality or under the Environmental Protection Act material? Because they have a much stronger definition of automotive salvage, and as you're all aware, you cannot be any less stringent than the planning, than the provincial government.
Thank you, Ben.
Don't know if I caught all the questions, but I'll.
But that's why I wrote them down, but I figured that I didn't want to use up my 3 minutes, like, as part of the answers. Just saying.
So yes, the industrial policy.
Yeah, because I mean, I don't want to tell you, the official plan is the main document that are moving forward. That was going to be the first or second one.
Yeah, so definitely the changes that are being proposed to the official plan on the commercial and the industrial uses were intended to provide flexibility so that council can look at things from all perspectives. It was incredibly narrow, possibly in violation of some of the other policies that were in the official plan that spoke to the limited expansion of existing operations. So yes, there is a little bit of a connection in those. The 8.3 in the bylaw, there's actually, it's a table and there's 2 columns, one's for interior lots, one's for corner lots, so that's, thank you, but we actually missed one instead of duplicating.
Okay.
The appeals, to the best of my knowledge, it has not actually been tested at IRAC yet, so I don't know what that's going to look like. But yes, the way the act was rewritten, it definitely, if you're an individual appealing, you have to be able to show that you in good faith think there's some impact on the reasonable enjoyment of your property. So that's going to be interesting to watch how they interpret what reasonable is and all of the different pieces. But if you're someone who has no direct impact and just on principle objects to something, you would not, the way I read the changes they made, have the right to appeal.
But if this gets approved as such, because it's related to the development permit application, it's an appealable decision?
The bylaw amendment would be, official plans are not appealable.
Okay, yeah, no, that's fine.
And on the salvage yard, I'd have to go back to the Environmental Protection Act. I think there are certain pieces that don't apply within municipalities, so that's always been a little bit of a challenge with the province. If it doesn't apply, then the stringency thing doesn't come into effect. So it would be looked at on a case-by-case basis.
Thank you.
Anybody else?
I just have a question, but I don't know if this is a question that.
I think we've already given you,
Okay,
we said 3 minutes, and I think we've probably given you 15. And I said I was cutting it off at 25, we're at 37 plus minutes since I started my stopwatch, so at 40 minutes.
So why has council?
This is ridiculous.
What reason did council have to approve this change to light industrial? Like what reasons are there? What evidence?
Oh no, you're cut off, Steve.
We received an application, and the decision we made was based on what our bylaw would allow and what the applicant is asking for.
So why what evidence do you have that this can be changed into light industrial, that it should be changed to agriculture?
Our bylaw allows it.
Your bylaw, but is there any soil testing done on, if this has to be unsuited for primary use, has there been anything, any evidence showing that this property is unsuited for primary use? Has the council provided any evidence that this property is unsuited for its primary use, its current use?
That's a yes or no, really.
Yeah,
That it's unsuited for its primary use?
yeah, and then it can be changed to light industrial.
Well, our bylaw allows us to take that application, and the individual owns both parcels, so he is in a situation where he's landlocked and structurally locked, and he's still operating a business that continues to grow. So if you got married and you lived in a house that was 800 square feet and you had 5 kids, you can't continue to live in that small house. You have to have room to expand. And like I say, in good faith, he's coming to us to ask us where before he's been told what he needed to do. So right now,
You see that that's very biased
Yeah.
towards the developer?
Yeah, super.
It's incredibly biased towards the developer. Like, the council's supposed to be pretty neutral in this and weigh the pros and cons. The question is, what evidence is there to indicate that the land is unsuitable for primary resource use? Because that is one of the primary considerations for this application to rezone. That's what's been stated.
that's part of our bylaw, and we also have a part of our bylaw that says that we can't restrict an operating business from reasonable expansion.
You can enforce. You can enforce and you have never enforced.
We haven't been asked to,
Well, now you've been asked to get 100+ complaints, so.
but that's after we made a decision to rezone.
You did make a decision, so you've already made a decision before tonight. I thought tonight was actually to discuss, so that you could decide tomorrow. Now you just let me, you just.
Now,
let me-
council has already voted on moving forward with the rezoning.
And who voted? Who was that?
And the first reading will be at our April council meeting, and the second reading will be at our May council meeting. And then after that, it will go to the province
Yeah.
and, for their,
So in the meantime, you have 100+ complaints sitting with council for review and consideration by almost over half a dozen residents in the area. So this is still in progress. This has not been approved, so the complaints have been filed before the approval of this process. So they should be addressed at the same time, not wait until this is approved and then address the complaints. The complaints are submitted, they need to be addressed and responded to, which includes enforcement and non-compliance with all the existing today bylaws as of today. Not future, which is what you're proposing to approve, but as of today.
I'm not sure if that's
That would be
within our
good
bylaw
process.
to,
Yeah, you don't review complaints 6 months down the road. You had no problem with the person with the bill, getting that resolved right away and slapping them with the $7,000 bill. It's all in your notes in your planning board meeting minutes and your council minutes. I've gone through them. Everything in your planning meetings, documents, there's actually quite a bit of biased comments towards the developer. But anyway, you should, if the complaints are not addressed in a timely manner, and the residents don't receive a response as to how the council's addressing that, then yes, we will go to IRAC or take legal action. You can't wait for this process to move. Complaints are in, complaints need to be addressed. Thank you.
I have a question. This future land use map amendment is here. Has this amendment been done?
that's why we're here tonight, to present the amendments. And
Okay.
then they have to be voted on.
But they
in
get
2
voted
readings.
on by whom?
Council.
Council. So you're showing us what you're going to do, but are you supposed to listen to what we say about what you want to do?
The rezoning is gonna the rezoning would rezone the property. That still hasn't
So
given
it's
the
not
developer to go ahead to do anything, because that's gonna be conditional on the development agreement that will have to be signed.
Okay,
You said.
okay, no, hold on, guys. Okay. I can't hear if you're talking over something, okay? Okay? Not all disabilities are visible. So I'm not deaf as opposed, but pretty darn near, and it's because I was in the army. So what I want to understand is that you're showing this possible amendment to the people of Miltonvale Park, but you're also saying it's approved already? Is that what I'm understanding? Now, please clarify it for me.
Council voted to proceed with the rezoning, and for that to happen, then the land use map has to match. And that's why we're showing the map presently and what it would be after the amendments are made. And then after that, then council would have to, and planning, put together a development agreement, which would have to be accepted by the developer before we would issue a permit.
Does this change have to be approved by the province?
Yes, it does.
Okay, so if someone has concerns, do they bring it to the province now? Samantha, sorry, I'm used to calling her Sam.
No, the province is not involved in municipal decision-making. The decisions, the province's role is looking at the submissions once council's gone through its process. Generally, when an application is received, it is brought to the public. The act requires that an amendment to the plan and bylaw that is brought to the public, and the public's given an opportunity to provide comments. Council is expected to weigh everything in the plan and bylaw, sound planning principles, what they heard from the public. So they've got a whole list of criteria that they look at, and the comments from the public is part of that.
So, in the minutes of the planning board, the council, there were 3 instances where the councillor did not recuse himself from discussions or the mention of the property rezoning. 3 instances. I think there's a code of conduct for councillors as well. So what happens when that happens, when the councillor does not recuse himself from meetings that directly relate to conflict of interest? Would you mind answering? I'm not really familiar with what's involved in that.
I can't speak to what happened because I wasn't there. Conflict is addressed under the Municipal Government Act. It's parallel but not part of the planning process. That absolutely would need to be considered. But I know that Sherry and the municipality look through these things. The Municipal Government Act does allow for applicants or someone who has recused themselves to still be at a meeting if they are the applicant or if they are affected. They're not there as a council member, and their conflict would be mentioned.
And they're not in the room when there's discussions made.
Yeah, actually, they were in the minutes of the council, that you can look at it line by line if you want the dates and the page numbers, where the council member, every meeting where there's a conflict of interest, they are to express that there's a conflict of interest. And on 3 occasions since the May meeting, they did not recuse themselves or acknowledge that there was a conflict of interest. You'll see in the notes, it comes back to an open meeting by Councillor Frizzle, and he stays there when they announce all the properties that are under consideration for.
She's done her due diligence.
I haven't missed a meeting in the 2 terms I've been here, and he has not been in a room where we
So
made
why
any
is it in the
decisions
meeting?
regarding the
Sorry,
application.
he is in the meeting because it says that he's in the meeting.
But he's leaving prior.
No, he's not.
No,
He
no.
opens the meeting for discussion.
Before his discussion comes up, though, he leaves the room and he's
No, he
gone.
didn't. But
He did, every time I've been there. He leaves every time because
Well,
that's,
this is hearsay. Your minutes are a reflection of the actual, they're a document from council, and it states on 3 occasions, he did not recuse himself.
but is
and
he not allowed to sit there throughout the whole meeting
He's supposed to
until
announce-
his part comes
No,
up? Then he can
are
leave.
you a counselor? Because it's in your code of conduct. You are to
Yeah, I'm a
recuse yourself.
counselor.
Okay, you are to recuse yourself, or every meeting where there's a conflict of interest, you are to explicitly say at the beginning of the meeting that there's a conflict of interest. On 3 occasions, there were not. There's just so many, I could go on and on and on, but that's fine. If you want to bring it to IRAC, that's fine. Just be, like, I hope you have some better evidence to support this decision, that's all.
Anybody else? Betty?
As a note to that, anytime they talked about the property next door to me, I had to leave the room, when I was on planning board. But it would have been noted in the minutes. But is the intent of this going forward, that the 4 properties in the same PID is going to be consolidated into one, and the
1.83 acres or whatever it was that said in the main meeting, is that gonna be subdivided off and then everything consolidated, so you have 5 parcels there as one lot? And then what type of buffer would one look at, even though they're owned by the same person, of going from, say, for example, light industrial to resource, agriculture? Because I know a buffer can be just a piece of land, but that's not much of a buffer, making it another parking lot. So I was just wondering what the intent is here, because you've got 5 parcels up there, even though 4 of them are under the same PID.
The 4 lower ones are all the same PID right now.
Yeah, but they're kind of like listed on the map as 4 individuals, even though they're under the. Yeah. Yeah, so there's 3 of them are under the resource, under the agriculture, and one's under the commercial.
The only thing that's commercial is basically the stem of the T, if you
Yeah,
wish.
that's right, which is a parcel, which has the same PID as the other 3.
And the other 3 have been added on, and they are still A1 zoning.
Yeah, those are agriculture non-conforming.
Yeah, but they're looking at taking those top 3 plus part of the other one and making it all industrial. So I'm asking if the intent is to physically subdivide it off, put pins on it for the part parcel, and consolidate, while you're at it, consolidate everything as to be just one parcel. 'Cause
I would assume it would be one parcel, because it'll be taxed differently being industrial than it would be agricultural A1.
He already has vehicles parked on 658799, which is agricultural use. The parcel where he's looking to, if you look at the PI soil survey, the 2023 PI soil survey, their aerial maps show that he already is parked on that property without authorization, and so he's already non-compliant there anyway.
Well, the vehicle parked on the other side of the access road too.
Yeah.
Quite a few
And there's
access.
entrance way permit, he doesn't have, like, there's so much more traffic going up to the other properties, I could go on, but there's just an endless list.
Have you driven up there yourself?
Yeah.
I have, yes.
Up to the pumping station, have you
I have.
driven up there?
Yep, in the last week.
Okay, and what, I mean, as a person living next door to it, what do you think my impression is? As I see expansion, and that's what we're trying to deal with here is, you know, he's got a great business going there, but how do you contain it? We're talking buffer zones or something. I never really seen anything in there that physically describes what entails separation from an industrial area to an agricultural area or to a residential area. I mean, Mr. Voss has llamas or whatever they are, llamas there, that are running right next door and in a barn. So he would have to have some concerns about noise and everything that would be expanding further along his boundary line. I don't hear anything in all of this that talks about addressing individual concerns of the neighbors or how this can better. By doing that, is there an order going to take place that all of the vehicles he has parked on the other side of the lane and up past the horse barn all have to be moved down on the industrial site? There's nothing in there that has any actions that need to take place. And we're talking about concerns about the perception of the place, and there's nothing that relates to that in here.
And those issues are all stuff that would be spelled out in a development agreement. Like the footprint that could be used after this took place, if it does, and you know, the type of vehicles that could be there, how long they could be there.
But wouldn't that be great to have now to delay some of our concerns?
But that didn't work for 1999 and 2008, so I can't understand why it would be different for 2024. The same conditions, even simpler conditions were put in place. and they were not adhered to. Again, once you go through the 100+ complaints and address those today, not 6 months down the road,
I think one of the earlier agreements said that he was restricted to 6 vehicles, like, I don't know any business that could operate, whether it was a body shop.
it's
Or-
like your house analogy. The house is too small, it might be time to move.
Well, he probably has 30 acres there, like,
So what are you suggesting though, with the 30 acres?
I don't know, he's the guy that wants to develop it, and we're just taking the application.
Well, I'm so unfortunate that's what you see your role as, because it's actually quite a bit more. You have a lot of authority delegated to you by the residents. And if you just see it as that, that's really unfortunate and not quite the right role for a council. Respectfully. That's a very biased comment. I'm just gonna let it go, 30 acres.
Right. Well, the developer, regarding the last question, the developer present a plan which, and he's proposing to put a berm around the portion of the property, because the proposal is just to rezone that portion, because the agricultural land is big enough. But, yeah, the last public meeting was to rezone just this portion, the gray one. And he present a proposal addressing all the issues that was presented in that public meeting. For example, for the separation between the zones, he's proposing a berm. So basically, now, we are following the process of the rezoning, which means, according to Bylaw, following the public meeting, planning board shall consider the feedback received from the public by way of written responses or comments made at the public meeting. The applicant may be provided another opportunity to present to planning board to answer any further questions that might be arising at the following public meeting. Planning board shall make a recommendation to council on the application. So that was our last meeting, our last public meeting. All the concerns, all the comments, there was a date to present. That concerns were discussed in the planning board. We talked with the developer presents a plan showing